And thank you for being here with us today. This is the 6th of our Grand Challenge sessions titled Getting to... Oh no, this is the wrong one, isn't it? It switched, didn't it?
Switched.
Yep, good. So it's the 7th one in the 6th one's place, and it is under the title of Breaking the Cycle of Exclusion for Stateless Minorities. Good. So we like to begin all of our Grand Challenges by remembering the many millions of people that we have gathered here on behalf of, several of those who are not permitted to travel here to be with us. So may I ask you to please set aside your phones and connect your hearts and minds with not just the complex issues of statelessness, but the people of statelessness. We read the words of Mayu Ali. Living under the radar, my culture is underground, or at least what can still be found. Should I attempt to be something I'm not? That's been tried. With some success, but alas, the soul is fried, a survivor of genocide. Can you imagine trying to live a lie, just so you can continue to survive? A fear to let the soul be free is what the legacy of genocide has done to me. Let the rhythm, cries, and language flow. I would, but so much I do not know. Let's unearth the culture and values that have always been. Community, environment, and sustainability. For many times, I feel as if I am living a fraud. A tribal South soul gagged and tied, yet still a survivor of genocide, blood-soaked.
Thank you very much for that. Good afternoon, ladies and gentlemen. My name is Joshua Castellino, and it's a pleasure to be chairing this particular grand challenge. A couple of caveats to start with. Apologies for those of you who are expecting this to be the gender panel. But in the best spirit of inclusion, we have moved early so that the gender panel can go into the slot that it was originally scheduled to be. So I hope that you're here to explore this particular challenge with us, which is how to break the cycle of exclusion for minorities. Also on the gender panel, apologies for the slightly misaligned and perhaps not as inclusive as it could be panel in terms of gender. And I think that's something that, again, I'm hoping that we will be able to overcome through the audience participation to a certain extent. So we are here essentially to look at the extent to which there are structural schisms in society that always seem to put the same groups in a vulnerable position. When you look at the world through the lens of groups that are far from sites of power, you see that it is the same communities that often face whatever it is that the violation will be. Minority Rights Group International, which is the organization that I'm privileged to lead, has just launched a report today, which of course shows you that environmental damage is not something that may happen in the future, or that might not happen at all if you ask some people, but that there are communities, indigenous peoples and minorities, who are facing the brunt of this challenge here and now. And I think that's equally applicable to statelessness. And we're here with a great panel to explore some of these issues and to really paint into the picture the fact that these groups that we keep thinking of as marginalized and vulnerable actually have a very clear identity. They are an identity that is somehow subaltern to the states in which they find themselves. And I think particularly in post-colonial states, about 85% of the world's states fit into that category more or less, you find that the choice to constitute a national identity on the basis of ethno-nationalism has meant that even though everybody knew the boundaries were artificial, there were foreigners created within. And I think this is, in a sense, what we are going to try and tease out today. It's a great panel we have. We have, of course, the UN Special Rapporteur, Fernand Devaren, who's taken key steps in linking the issue with minorities and statelessness. Fernand had a forum in November which explored this issue in quite some depth, and I think Fernand will try and paint a wider picture for us in which this question sits. We'll then follow that up with Mustafa, who'll talk a little bit about the situation in East Africa and really the extent to which this is a wider issue. Some of you before this panel may have seen the launch that took place in the newsroom about statelessness in East Africa. I encourage you to go back and find out more about that. Julia will then talk about something much closer to home with the Roma, again, very often a forgotten community, and will show you the impact of these discussions even in places where statehood has had far longer salience than in the post-colonial world. And we'll finish with South Asia. Khalid will talk first about Biharis in Bangladesh, showing you really the fact that Bangladesh has many different challenges on statelessness. And we'll finish, I guess, with Ravi, who will speak about something that is extremely contemporary, which is the fact that 4 million people risk being made stateless as a result of the Nrc, the National Register of Citizenship, that's taking place now in Assam. So without further ado, I'm going to invite Farnan to speak. Each of the panelists have around 8 to 10 minutes. I've been bargained up to 8 to 10 minutes, I'll have you know. But I want to try and leave enough room for you to engage the panelists and also give your own perspectives. So please welcome UN Special Rapporteur Farnan Devarin.
Thank you, Joshua. Distinguished guests, hello everyone. First, let me express my gratitude to the Institute on Statelessness and Inclusion, its sponsors and organizers of this international conference, for the opportunity and privilege of not only participating in this panel, but also for the possibility of sharing and exchanging views with you, and especially such a distinguished group of experts and activists. And I would like to exchange a few thoughts particularly on the growing challenge the world is facing. But before I do that, I have to say that I'm quite relieved I even made it. I had to cross the Atlantic Ocean twice in 48 hours, and closer. And just arrived, in fact, a couple of hours ago from Canada. And I definitely had to have 2 or 3 cups of coffee before I even could start talking here. Let me respond to this grand challenge session by breaking, perhaps in terms of breaking the cycle of exclusion for stateless minorities, by doing exactly that, challenging what might seem to be its premise. The primary cause of exclusion is obviously the statelessness of millions of minorities around the world. And this can be broken in 2 ways, and both are based on a human rights approach. The first, I have to say, is more reactive. Even when individuals are deemed not to be citizens, access to many basic services and rights are in the area such as in the area of education or access to basic public health cannot be limited to citizens. And I think sometimes we forget this, or governments even forget this. There are international human rights obligations, such as the prohibition of discrimination, that can be powerful tools to dispel the misunderstandings which were even propagated, we could say, by famous writers such as Hannah Arendt, who wrote that citizenship was the right to have rights. Well, that's not quite true, is it? Not today. It might have been true during the time around the Second World War, or soon after that, because human rights in terms of legal obligations were not actually in place until much later. But today, that's not true anymore. In reality, even if individuals have no citizenship, they do have rights in the area of education. Children have rights, whether they are citizens or not. Individuals have rights also in this sense. So there is sometimes a misunderstanding which still exists out there, and that even governments, a number of states, believe that because individuals are not citizens, well, they can treat them in any way they want and deny them actually what are basic human rights in a discriminatory way. And this, I think, has to be highlighted and is not always well understood. This is a tool to address the exclusion of stateless minorities, which needs to be much better understood, appreciated, and used. The other approach is also mainly premised on the prohibition of discrimination to prevent or to stop the initial cause of exclusion. And this is the actual denial or refusal to recognize the citizenship of minorities in a discriminatory manner, because statelessness does not simply happen in relation to minorities. Very often around the world, the largest groups of stateless people are minorities who are targeted, and I use the word targeted, by policies, practices, or legislation with the intended, whether it's referred to or not directly, the intended decision to exclude them. And quite often we have here the situation, because that this is discriminatory, of a violation of one of the most fundamental human rights, which actually causes or results in the statelessness that results in their exclusion. This is how you have to break the cycle, by preventing when there's possible, or addressing in other ways the discriminatory practices and conduct, which results in the exclusion of statelessness. Now, that might sound simple, but of course it's not. And there's also here an elephant in the room. The reason statelessness is a thematic priority of my mandate, as Joshua mentioned, and was the focus of last year's UN Forum on Minority Issues, held in Geneva, as it was mentioned. And the reason also I presented in March a report to the UN Human Rights Council on statelessness, as well as one to the General Assembly last year in New York, and also the reason why under my mandate I called upon a group of leading international experts known as the Galway Gang to work on the world's first set of practical guidelines to how to address most of the world's cases of statelessness. And because I assume all of you know, but maybe not, I hope you realize that more than 75% of the world's stateless people are minorities. And they tend to be specific minorities that have been targeted. I was recently reading an excellent article on Hannah Arendt, once again, on her concept of statelessness and how it could be used as a framework to presenting the current situation of refugees on the one hand, and providing a criticism of international human rights on the other. Now, the premise, and this is where it struck me that perhaps we don't understand statelessness as much as we should. The premise was that statelessness was intimately connected for most to their refugee status. And I found that striking. And in fact, perhaps it explains to a large degree why even in the UN system, as you know, statelessness matters are considered to fall under the mandate of the UN High Commission for Refugees. On that logic, breaking the cycle of exclusion for stateless minorities needs to address the humanitarian crisis which has led to their refugee status. But of course, that's incorrect, that's false. The exclusion of stateless minorities must be clearly focused and invoke human rights obligations, such as the prohibition of discrimination in the two approaches that I described, because in the end, most of today's stateless contexts where minorities end up being those around the world who are most affected by statelessness is not connected to refugees' status situation. Initially, the Rohingya in Myanmar were not refugees. They were long-time residents, even generations, in Myanmar. They only became refugees when the situation in Myanmar led them to actually flee the country. But they had been deemed or denied citizenship by the government of Myanmar by legislation. And I find this misunderstanding surprising. It is surprising how much the United Nations, my own organization, and many other entities doing excellent work on statelessness issues, including, of course, the Institute here, don't mention minorities often enough, I think. Remember, minorities, more than three quarters of the world's minorities are the stateless, or the stateless are minorities. So because they end up being the main victims of statelessness, shouldn't they be the focus of our approaches, our solutions, our initiative to tackle this situation, horrific situation of statelessness? Think of the approximately 1 million stateless minority, the Rohingya. About 10% of the world's stateless, which is assumed to be around 10 million officially, as this 1 million stateless are one minority, one single minority which is being denied citizenship, which they actually had previously under legislation in Myanmar. So I think that we need to be honest, we need to be direct, and we need to be transparent in the campaign to eradicate statelessness. Because if you look at the campaign to eradicate statelessness, which has been very effective in a number of ways, and the 10 actions plan, the word minority is never even mentioned once. although the UNHCR, to its credit, in 2017, actually did build efforts around the theme of minority, but I don't think that's enough. I don't think it's enough when, once again, I want to emphasize a point. More than three quarters of the world's stateless people are minorities. Why aren't we talking all the time about that here? Around the world, the largest groups of stateless people in every continent are minorities. They tend to be one specific minority. In Europe, it's the Russian-speaking minority in the Baltic states, and then the Roma. In Asia, currently, the Rohingya. In the Americas, the Dominicans of Haitian descent. These are not coincidences. Statelessness does not simply happen. What you have here are the results of policies, practices, legislation that target, aim, and impact on specific minorities. I don't know if you noticed, I think at one point I used the word more than 75%, three-quarters of the stateless minorities, of the stateless are minorities. In fact, that proportion is very likely to increase, and to increase dramatically this year. There is, in India currently, a series of procedures in place in Assam, the state of Assam in India, which may have astounding results. We don't know. It's very difficult to determine right now, but there are currently procedures in place in Assam that may result this year in somewhere between 2 and 4 million people. I think it was mentioned earlier, and Ravi will be talking in more detail about that. There's a potential right now of up to between 2 and 4 million people being deemed to be stateless. Many of them, without concluding on this issue, because it is quite complex, many of them actually have been there their whole lives. They were born there. Their father and parents and mother may have born there. There are generations that may be involved. And most of this group of 2 to 4 million people, most of them actually belong to one minority group. This is not a coincidence, or at least it seems that it's not a coincidence. I'll let you judge whether it is or not. And I'm mentioning this because we are not eradicating statelessness. We are not even diminishing statelessness around the world. It is currently exploding if these procedures run their course this year. And even by the end of July, we may be facing a total failure of directly addressing the causes of more exclusion. A press release is being issued today by myself and some of my colleagues in the Special Rapporteurs of the United Nations on this matter, which includes the statement that we will be raising this directly to the UN General Assembly, the UN Secretary General, and the United Nations High Commissioner for Human Rights, not only because the apparent large-scale exclusion of minorities, large-scale racial and religious discrimination may be involved, but because also the scale of this exclusion may result in Assam having becoming a potentially destabilizing situation for the region, of creating another massive humanitarian crisis, and potentially causing a gigantic or horrific human disaster, with generations upon generations of millions becoming destitute and desperate. If you have millions of people overnight almost being deemed to be stateless, they have almost no rights. Difficulties they'll have situations of exclusion. They may not be able to have access to education, public health service, ownership of property, access to many categories of employment. And this will not only be those who are directly affected today, but generations, their children, and perhaps their grandchildren, and so on. So if you think 1 million Rohingya from Myanmar was an unprecedented situation, think of 2, 3, or perhaps even 4 times that number, and what it means in terms of the international community's ability to respond. That's what we have to do if we want to break the cycle of exclusion. Let's address those cases which have not yet led to the situation of individuals being deemed stateless. Now's the time. And I'm hoping that perhaps we will continue to address this and other situations. Thank you. Thank you very much.
Thank you very much, Fernand. Mustafa.
Good afternoon to you all. I have a big challenge given to me now after the rapporteur has already spoken. It's hard to speak after him because he has already captured all the problems that we are facing. I come from a minority community, an ethnic minority community called the Nubian community. And basically, I'm going to share with you our experience as minorities in Kenya. Just a brief background. In 2009, OSGI commissioned a census for the Nubian community because for years, after every 10 years, the country conducts census. But my community was already part of the group that was clustered as others. So we could not know how many we are. So until 2009 is when we could get a clear estimate that we are approximately 30,000. There's a reason as to why I've given you this background, and you'll find out in my presentation. Okay, just a background of nationality in Kenya is that our nationality law takes us back to 1963 when we got our independence. So basically it tells us that any person who was in the country by 13th December 1963 is by default a Kenyan. But is it the practice? Now, there's a difference between the law and the practice in Kenya, and this is what I'll be demonstrating. Another problem is during the colonial era, the British colonialist government decided to divide the country into 43 districts for easier administration. But now it was called tribal districts. But unfortunately, Nairobi, which was the capital city, wasn't considered as an ethnic district because it was cosmopolitan. Everybody could come to Nairobi to come and work. So the biggest settlement of the Nubians is in Kibra, which is apparently still in Nairobi. So you can see one of the problems being that we can't be identified as people from that district because it's considered to be everyone's place. Another major challenge is the discretion that the registrar is given because it's clearly written on the form that the registrar can ask you for any additional document that he deems necessary, to the extent that he could ask you for a title deed, he could ask you for any document, even your great-grandparents' birth certificate, of which him or her could not even produce his mother's birth certificate. But for you, he'll expect you bring it. Then every community migrated from somewhere, but for us, we are haunted by the fact that we migrated from the Sudan forcefully. Forcefully migrated by the British to come and fight for them by 1889. So the biggest problem that the Nubian community faces is that they're restricted on days that they can apply. You can only apply either on Tuesday or Thursday, and you can only apply between 9 a.m. to 12 p.m. or 1 a.m. before they go for prayers. The reason as to why you can only apply on Tuesday and Thursday is because the vetting elders only sit on those 2 days. The rest of the Kenyans can apply any day, anytime during the working hours. So another problem is, how do they identify you as a Nubian? Because there's a small form when you're filling for an ID, it's called the RIS form. When you reach the part of the tribe, and you write your tribe is Nubian, you're told, well, you cannot continue the application. You have to come on Tuesday or Thursday so that your elders can swear an affidavit that they know you, they know your parents, they know your great-grandparents, so that you can proceed to the next step. Is it practical for 2 elders to know 30,000 people in the community? It's very impractical. After that, after the elders have sworn an affidavit that they know you, yet they don't know you, you're now booked for a vetting, which is the security vetting. Basically, you go and appear before the National Intelligence, Criminal Investigation Department, the security officers like the chiefs, DC, and all that. And there's only one person that comes from the registration department who's the secretary to that committee. So there's only one relevant person that you were supposed to have been in front. But basically, you're grilled and asked questions like, where did you go to school from? Have you ever crossed the border to go to Uganda? Have you ever eaten certain food? And the funny part is that one of our former deputy presidents, Mudi Awori, his elder brother was the advisor of the president of Uganda. But it's okay for him to have a brother in Uganda and still be a vice president in Kenya, but it's not okay for a Nubian to even study in Uganda. So the double standards. Another challenge is the arbitrary denials in documentation that we have faced in years. So basically, you just wait for years and years. You don't know if your application has been rejected or not. Every time you go, they tell you, wait, come back next month, come back the other month, because they don't want to tell you that you didn't qualify to get an ID. And at the end of it all, you can lose the interest in the process. So what did we do? In 2001, after all these compounding problems, our elders decided to go to the High Court with the help of an organization called Semi-Right to go and get a constitutional interpretation of whether we are Kenyans or not. Now, the irony of it is this. When they went, the judge who was sitting on the bench said, for me to be able to see the admissibility of this case, I would want you to bring me 100,000 signatures accompanied by ID numbers from your community. Yes. So that you prove to me that your community is dissatisfied with this process. I want you to go and bring me 100,000 signatures from your community with their ID numbers. And the challenge is getting IDs. Remember, I told you we are 30,000, but now we are supposed to present 100,000 signatures. So after that denial from the national level, we decided to go to the regional decision makers because there are several judicial mechanisms within the AU system. And with the help of OSGI, we were able to go to the African Committee of Experts on the Rights and Welfare of the Child and the African Commission on Human and People's Rights. And basically, we got 2 decisions. We got the Nubian minors decision in 2011, and we got the Ali versus Kenya decision in 2015 that basically clearly said that by discriminating against the Nubian community, the Nubian child, by subjecting them to discriminatory vetting, it subjects them to the risk of statelessness. It's now 8 years since the 2011 Nubian minors decision. Nothing has been done. One of the recommendations is that not only the Nubian child, but the Kenyan child does not have protection of nationality at birth because the birth certificate clearly writes that this is not proof of nationality. So the question is, what is the proof of nationality at birth in Kenya? The only people who get proof of nationality are citizens by registration because they get certificate of registration, which is proof of nationality. But now, Kenyans by birth, what is the proof of nationality? Basically nothing. So in 2013, 2012, the idea of the Paralegal project was brought up. And in partnership with Namati and Open Society, Nubian Rights Forum began the project in 2013. And so far, they've handled over 10,000 cases. And basically, the whole project is structured behind the Nubian miners' decision. The idea was, can we be able to empower this community that there is a decision that really supports your case? There's a decision that basically says you have the right to nationality, and the Constitution also enshrines that. At the same time, monitor the application process. What are the documents asked? What are the days, what are the documents asked, questions asked? How long does it take from the first day to the government office that you visited to the day that the document has been issued? So the paralegals work with the client. They don't do it for the client. They work with you the process, so that sometimes just working with someone gives them the feeling that I have a right, I am safe. By that motivation, someone can be able to go and apply. And we've seen a lot of people that because they had a paralegal accompanying them to apply for a document, they got the courage to apply again after basically losing hope. So that was a picture of one of the paralegals. So the project has grown beyond the Nubian community. It's also helping the Somali community, the Kenya Somali community, the Swahili community, and right now we have 24 paralegals from 3 partners. Now it's 4 partners. One partner in Mombasa, 1 in Garissa, 1 in Wajir, 1 in Nairobi. So basically the idea is to monitor the whole process, document it, and then use data to do awareness on what is there and what is the role of the citizen, and also do advocacy. So one of the things that our partners do is that they do radio projects, awareness, to talk about these issues. Like right now we have a new identity system that it's called Huduma Number. And the whole of this year, we've been trying to talk about what are the pros and cons of the whole system and how does it affect minority communities. So radio is a big tool that we use. And we've been able to gather a lot of support from the rest of the Kenyans, because people basically only support you when you talk about issues that affect them. They realize that minorities are now teaching them the right of privacy and the right of their data not being used and being sold to corporates. So we've been able to use the paralegal data to submit reports to the African Committee of Experts. In 2014, we submitted a paper. Namati, Nubian Rights Forum, and OSGI submitted a paper to African Committee of Experts on the Rights and Welfare of the Child, showing that the government has done nothing in terms of implementing the decision. In fact, they've even made it harder for Nubians to get IDs, because right now, for a Nubian to get an ID, after the vetting, your parent has to come physically and put his or her thumbprint on your form, which is not a legal requirement. But basically, because the registrar has the discretion to ask for anything, he can ask you for such. So we've been able to use data also on the radio. And when we had the Huduma number, Huduma in Kiswahili means service. A number is just a number in Swahili. So basically, the government has launched a new database that they call it a single source of truth, as Bronwyn had mentioned yesterday. Basically, they want to amalgamate all the registers into one register and expunge any person that they think was not supposed to be in some of these registers. And the biggest losers of such system are the minority communities like the Nubians, because during these 4 months, there was no vetting, because the same people who are implementing the Huduma number are the same people who are supposed to vet you. So basically, nothing. No Nubian could apply during this period of time. And in South Africa, where I was with Bronwyn, the government official said, we've registered 90% of Kenyans. Only 10% refused to apply, and some of them, we turned them away because they didn't have supporting documents. Who are these 10%? The minority communities who the government has denied documents. So we've been able to go to court on this Huduma number, basically showing that this new system will further marginalize minority community, because without this Huduma number, you cannot access any service. You cannot access even your SIM card, because the government was threatening to cancel the registration of all SIM cards if you don't have a Huduma number. And without an ID card, you cannot get a Huduma number. So basically, minority communities are to be locked out completely from accessing anything. So my last, that's my last. So basically, paralegals have played a pivotal role in terms of not only empowering the community, but also holding the government accountable in terms of their service delivery to the people. Thank you.
Thank you, Mustafa. Julia? Yeah? To go up here.
So, hello everyone. Okay, sorry? Yeah, I do, thank you. So hello everyone, thank you very much. I'm very happy to be here in this distinguished panel, and it's very difficult to go after two such brilliant speakers, but I'll try to do my best. I really enjoyed two presentations before. So my name is Julia Stardelic. I'm Dr. Julia Stardelic. I'm a Marie Sklodowska-Curie Fellow at the University of Leuven in Belgium. I'm originally from former Yugoslavia, but now work there, and then I'm going on to work as a lecturer at the University of Wellington in New Zealand, where I'll teach human rights and the politics of forced migration. But before I started working in academia, I have a decade-long experience in working in Romani communities, especially in the former Yugoslav space, from Slovenia up to the communities in Kosovo. And I'm not, so I did a lot of research from 2012 on the position of Roma, who ended up either without legal documents or without, and ended up at risk of statelessness and stateless. There have been two very good, excellent presentations already from civil society activists, Senada Salih from the European Roma Rights Center and from Elvis Berisha from the Roma NGO Firma Mensa. So they all represented a lot of details. What I'll try to do in this presentation is actually do a little bit more of a theoretical overview and also comparative overview of, and this doesn't seem to be working. What should I click? Okay. I do socio-legal research, and what I do at the moment, my research is funded by the European Commission, Marie Curie Sklodowska. I'm trying to show that actually Roma, the position of Roma is very much comparable to the position of many other minorities around the globe, especially indigenous people, but also African Americans. So there are like many issues of discriminations the Roma are facing around the globe, but also especially when it comes to the case of statelessness, and this is not visible in the slide. And what I'm going to try to do today is also do a little bit of a comparative and theoretical overview. The title of my presentation was From Citizens to Aliens, an Inquiry into Racialized Citizenship and Minority Statelessness. So, but I'll start with two anecdotes. When I started doing my research on statelessness in different former Yugoslav states, especially on Romani statelessness, one of the state representatives in Montenegro said to me that Roma statelessness will just disappear, that this is an issue that will not be there anymore in a couple of months. And that was in 2012. In 2019, we actually see that there are more and more cases of Roma who are stateless coming out. So it was not actually swept under the carpet, as the state representative said. And the other thing that was really interesting, another anecdote from my field work, was I talked to one Romani NGO activist from Bosnia and Herzegovina who said to me that he's very proud of his wife because she gave birth 15 times that year. And what that actually meant was that she was lending her healthcare card to other, basically Romani women who did not have health insurance, basically because either they lacked documents, legal documents, or they were at risk of statelessness, or they were the Euro stateless. So these were three categories. And what this shows is actually that what we have many times heard already in the past 2 days, that statelessness is an intergenerational problem and affects kids. And it's like basically children inherit that from their parents. And what I wanted to do, because most of my research is on minorities, here you know this is a little bit of a different quote referring to the animal animal farm, that all citizens are equal, but some citizens are more equal than others. When it comes to minorities, we see this in a lot of places, but what I argue in my research, also when it comes to access to citizenship. When we talk about access to citizenship, we have on one hand statelessness and the question of lack of citizenship status, but if we go back to theoretical texts like Hannah Arendt's text that was already mentioned before, we have to question now whether the lack of citizenship status also means the lack of rights associated with citizenship due to the lack of the reader's legal status. And I say where we have also the lack of rights, we have the total infringement of citizenship. And this happens not only in the case of Roma, but it happens, of course, in other different cases around Europe and around the globe. So when we talk about minority statelessness, we heard already the data today that 75% of a stateless person belong to minorities. However, what I try to show in my research also that not all minorities are equally vulnerable to statelessness and access to rights. And the question that we have to actually ask also, what makes a minority, any minority, particularly vulnerable to statelessness? Sorry, I went a little bit too far. So, but the question is it only we question ethnic discrimination? Is it state disintegration is the case of former Yugoslavia, also like disintegration of Czechoslovakia and Soviet Union? Is it past colonialism? And what are the basically mechanisms behind that cause statelessness? And I think that we need a new vocabulary here. And I did a socio-legal inquiry in 5 different cases of statelessness. Of course, I focused first on Roma because this was one of the cases that I really studied thoroughly. But to compare them to Russian-speaking minorities in the Baltic states, children of the winter generation, Dominicans of the Haitian descent in the Dominican Republic, and the Rohingya minority in Myanmar. And what I have found out, starting with the position of Roma first, is that we have very, very different contexts around the globe, but we have some similar, very similar principles, same principles. So what I argue is that states constructed these minorities as stateless by introducing legislation, discourses, practices that retroactively transform these minorities from citizens to irregular or illegitimate migrants. So there is a very famous saying in the irregular migrants movement saying that even when people do not cross borders actually cross them. And I do believe that this is something what happened with many minorities who were not primarily forced migrants, but became forced migrants after they became stateless. This is definitely the case with many cases of Roma statelessness, but also with, of course, with Rohingya minority and so on. And what is very interesting is that there is a lot of construction of migration, but also state denial. If you remember the actually report by the minority rights group, denial and denigration, I actually wrote a piece on Roma for this report. And we see that there's a lot of denial that actually statelessness is going on. Usually they say that there is basically some unresolved issues with legal papers and so on. However, we see that there is denial of, there is denial of racism. And the other thing that I'm trying to argue is that basically the lack of citizenship does not, as we heard already today, does not necessarily transform into the lack of the right to have rights. It does often, but not always. And what I do believe, we talk about ethnic discrimination, we talk about state disintegration, we talk about past colonialism. I do believe that when it comes to many minorities, we also need to start thinking about racialized citizenship regimes. Because I do not believe that the statelessness of Roma actually happened just because there was war in former Yugoslavia or there was state disintegration in the Czechoslovak case, but because there were certain policies that were there in place that actually targeted like certain groups, even though it was not visible directly. So I'm using the definition of David Fitzgerald, who is a professor at University of San Diego in California. That citizenship is racialized when rights are being denied on the basis of inalienability of belonging. So no matter what this minority does, they cannot actually access citizenship because they are belonging to a certain group. And like I said, I'm not going to talk in details about the case of Roma because we have heard two very good presentations before. However, as I mentioned, there were like 25,000 Roma who ended up stateless after disintegration of Czechoslovakia in '93. The discourse of the Czech Republic was that these are the people who actually have Slovak citizenship, although many, how many? 2 more minutes, okay. Although many of them actually never ever lived in Slovakia, but were moved during the socialist times. They were moved from Slovak part of the federation to the Czech part, but never properly registered in the Czech part. So that's the case of Velvet Divorce of Czechoslovakia. The other case that I'm really actually very happy that we're discussing here, because it's a very, very serious case after the disintegration of former Yugoslavia, and it was trying to be like swept under the carpet many times, is the case of after the Yugoslav disintegration, how many Roma ended up as stateless. There was, of course, physical violence, but I'm using the post-colonial literature here to say there was also epistemic violence that transformed citizenry in former Yugoslav states and said who can belong and who cannot belong. And again, it was usually the claims that the Roma who were without documents were actually citizens of another state, and they're actually coming from another post-Yugoslav state. And actually similar things happened with the Russian speakers, although I remember at the Forum for Minorities in November when one of the representatives, I don't know which it was, if either of Estonia or Latvia, said that there are no stateless people in the Baltic states because of the difference of definitions and so on. But the thing is that actually here again, these people who came to, who were part of the Soviet Union were then again seen as foreign agents, as people who were brought here by somebody else as migrants, although they were here before the countries were established. Similarly, in Windrush affair, which is still not actually researched enough, is that the UK destroyed the landing cards that proved citizenship of people who came from many generations before, who came from Caribbean countries. And also in the case of Rohingya minority, you can see that there was a claim these are like actually Bengali illegal migrants and not minority of, so there was a change of discourse at a certain point, which is very similar. Again, similar thing with the people of Haitian descent in the Dominican Republic. There's always this kind of discourse, racist discourse from racialized citizenship regimes that says, okay, these people were from somewhere else, not from this country. And when I talk about minority statelessness, I actually do think that there are shades that need to be addressed. So for example, okay, we have like Russian speakers in the Baltic countries do have certain rights, but do not have right to political participation. Then Romani minorities, the ones who are without documents and the ones who are stateless, usually have problems even proving that they're stateless. And then we get to the so-called refugee crisis when it comes to Rohingya in Myanmar, when we have also cases of that can be considered as genocide. And what I would like to conclude is we heard that many times already that statelessness is not an accident. It happens to particular minorities, and we have different shades of statelessness that need to be addressed. We need to hold states accountable, especially for not just for statelessness as such, but also for minority statelessness, and also for the total infringement of citizenship. And the last thing that I said, and also we need to start talking not just about ethnic discriminations, but also racialized citizenship regimes. Thank you very much for your attention.
Thank you very much. Thank you very much, Julia. Please, Khalid.
Thank you. Hello, everybody. I'm going to talk about the story of the migration, statelessness, and citizen, and then exclusion. It's not working. Yeah. I belong the Bihari Urdu-speaking linguistic minority and formerly stateless person. Before 5th May 2003, I considered to be a stateless. Because of 1947, the historical creation of India and Pakistan, and the mass migrations of Hindu, Muslims, and Sikh community. Basically, the Urdu-speaking people, we are living in Bangladesh now in 116 camps. We migrated in 1947 and 65 from the state of India, Bihar, Uttar Pradesh, and West Bengal. And during the Pakistan period, in 24 years, the Urdu-speaking people were the privileged community because of their language and their culture. But in 1971, within the 24 years of Pakistan period, the Pakistani government and army, they neglected to the Bengali nations, and the Bengali community faced the discrimination in every way of their life, so that they have started the agitations to separate the country, independent country. And finally, within the 9 months of civil war, the Bengali has created the new country like Bangladesh. So Pakistan has been broken in West and East Pakistan. So during the war, in 1971, a section of Urdu-speaking community opposed the creation of Bangladesh, and they cited to the Pakistan army. So that after and during the war, the Bengali community started the killing to the Bihari people, and they looted their property, and they became stateless. In 1972, ICRC, International Community for Red Cross, they took the responsibility and provided the shelter and food and medicine, and they established 116 camps all over in Bangladesh. These camps look like the refugee camps. Still, these camps are existing. After Bangladesh, the Bihari treated as so many nomenclature. Like some people say these are the Bihari, non-Bengali, stranded Pakistani, Mohajir. Mohajir means refugee. And underlying assumption was they are not Bangladeshi citizens. They are non-Bengali. But in 2001, when we grow up, in the camp. I born in camp in 1981, in Geneva camp it's called. So we have seen discriminations every way of life. Like the Biharis are living inside the camp. They are not Bangladeshi citizens. We don't have any access to go to school or get any civil documentations. Then we decided we have to find our route. If we are a stranded Pakistani, then we have to go back to Pakistan, or we are Indian, then we have to go back to India. But the camp life is very serious discriminations. So we decided with 10 youth from Geneva camp, including me, we filed a writ petition in High Court in 2001. And we claim ourselves, we are by-born Bangladeshi citizen, and our name is missing in the voter list. We didn't say to the court, we need the citizenship. We claimed we are citizen of Bangladesh, but our name is missing in voter list. Just after 1 year, 5th May 2003, the High Court has declared that this 10 petitioners from Geneva camp, they are by-born Bangladeshi according to Bangladeshi Citizenship Act. But that was a silly mistake with us. We claim ourselves just 10 people we want include our name in the voter list. According to our petition, the High Court has declared to the Election Commission to include our name in the voter list, just for the 10 people, not for the all. But in 2007, when the Bangladesh government announced the national ID card first time in Bangladesh, and there were so many importance of the national ID card. If you have the national ID card, you can enjoy these and that opportunities. Then we realized we 10 people will get the national ID card, but other community people, like 300,000 Urdu-speaking people living in 116 camps, they will be deprived. Then we motivated to the other community people from the Mirpur camps, and then again in 2008, they filed another writ petition in High Court, and they said, we all Urdu-speaking people living in 116 camps, we are Bangladeshi citizen, and our name should be included in the voter list and national ID card. And just on the same year, in 18th May 2008, the first time High Court again declared these Urdu-speaking people living in 116 camps, they are Bangladeshi citizens. And the first time we got our nomenclature from the High Court that these people are called Urdu-speaking Bangladeshi. So after getting citizenship, still the social exclusion is going on. You can see the people are living in very miserable life. The camp situation is we have 10 to 10 feet house, and the people are surviving 10 people, 6 people, and 8 people. There is no space for the cleaning and the cooking. You can see the first hand of picture is the bed is very high. The people are sleeping in up and down, and there is no any access for the kids for the playing or study. So exclusion is still going on. In June 2013, Namati and Council of Minorities started the joint paralegal program because after getting the citizenship, it is very important for us to get the birth certificate, passport, national ID card, and trade license for business. So we had so many problems to get the birth certificate for the camp kids, for the Bihari, because of their camp address. When the camp people apply any birth certificate, there is administration say, oh, there is the Geneva camp or Market camp or so-and-so camp. Then they say, no, you are a standard Pakistani. You are not able to get Bangladeshi citizenship or any birth certificate or any passport. But there is a two very strong judgment from the High Court. They don't know about that. So we decided we have to start the paralegal work, and finally, in June 2013, we started the community paralegal project in 6 major cities, and the paralegals are assisting to the camp dwellers to get the birth certificate, trade license, national ID card, and passport, and even they are doing everyday door-to-door outreach, and they are disseminating the message of importance of the civil documentations, and also the one thing we believe this is important to inbuild within the community people the 2008 court judgment. Because if the community people will believe they are Bangladeshi citizen, how they are citizen? You know, sometime the government officer challenge them. No, you are living inside the camp, and camp is still treated as a standard Pakistani camp. So if you know about 2008 court judgment, then you can argue with the government official that no, we are living in the camp, we are Bihari, we are Urdu speaking, but we are Bangladeshi citizen. So here is a table you can see. Within 5 years, we have achieved so many civil documentations like birth certificates, consular certificates, national ID card, passport, trade license, and so many civil documentations we have received within these 5 years of the project. So here is some picture. The first time in 2013 when we organized a birth certificate distribution program, the first time the camp dwellers are getting the birth certificate without any brokers, without paying extra money. And there is the passports. And along these projects, we have community group meeting and community forum program because we believe this project is going on since 2013, but we need to sustain the project. So we are trying to inbuild within the community about the process and how they will get the birth certificate or passport or any documentations. So here is some figure of the group meeting. Around 14,579 people has been learned about the process, about the civil documentations and 2008 court judgments. Here are the pictures of the group meeting. Sorry, it's not working. So again, the issue of passport, like in 2003 and 2008, is a long period, but the camp dwellers are still facing passport issues. In some places, the camp dwellers are getting passport with the address of the camp address as a Bihari. But in some places, like in Dhaka, there is still discrimination is going on. Like when they apply for the passport and there is the address and the authorities say, no, you are Bihari, you are rejected. Because you are living in the camp and camp is not registered, you don't have any electricity bill, you don't have any property bill. But in some places, the same thing is, in some places outside Dhaka, the people are getting passport within the camp address. So within the one country, there is two practices. Then after we organized an advocacy meeting, and we invited some experts and some lawyers, and we say there is argument of the special branch officer when the Biharis are applying for the passport. A special branch officer said the Biharis and Rohingyas are not able to get passport, and then we and the paralegal we challenged to the special branch officer. So do you have any documents or anything? They said yes, we have the written statement from the Home Ministry, and the Home Ministry said the Biharis and Rohingyas are not able to get passport. We say Rohingyas are refugee or stateless, but we are citizen of Bangladesh. So why we are deprived to getting the passport? Then they say no, I am not going to give you the written documents. After that advocacy meeting, the people recommended me to go through with the RTI petition, Right to Information petition, and ask to the Home Ministry in which laws or in which argument you are denying to get the passport to the Bihari. And then in 2015, I filed a RTI petition in the Home Ministry, and simply I just asked to the Home Minister, in some places, Biharis are getting passport, and in some places, they are not getting passport. And they are Bangladeshi citizen according to 2008 court judgment. So do you have any policy to provide the passport to the Biharis? Just after 1 month, they provide me 6 pages answer. And the answer is very much clear. And the Home Ministry said, if any stranded Pakistanis have national ID card, they are able to get passport. So after that, with this order from the Home Ministry, then we reapply the passport again with the market camp couple, and they got passport with this order. But at the same time, there is the applicant in Geneva camp, and we apply again the second time, and again the special branch officer said, no, we are not able to get your passport. We say we have the order from the Home Ministry. They say, this order, I don't have this type of order with me, so I'm not going to provide you the passport. Then the same one client, again we apply the third time, again rejected. Then fourth time, again rejected. Then fifth time. The special branch officer said in the fifth time, okay, you have to provide the two letters one from the Pakistan government that you have rejected the Pakistani citizenship, and then one letter from the High Court. You just claim yourself, I am just accepting Bangladesh. I say, how can my client go to the Pakistan? There is no relation between the Biharis and the Pakistan to get any certificates or any documents. So then we stopped the applying again and again. So we filed a complaint to the National Human Rights Commission in 2015. And then National Human Rights Commission issues 7 letters to Home Ministry and CC to me. And they said, please come and resolve the issues of the Biharis. But there is no any solution. There is no any response from the Home Ministry still. Yeah, the other challenge is, again, the draft citizenship bill. As you know here, someone in Bangladesh, 2016, they drafted a draft citizenship bill, and there is some sections which is created the new circumstances of the statelessness, including the Biharis and some war criminals' families. They will be stateless if this bill will be enacted from the parliament. Then we have started advocacy program, the nationally and internationally. We organize roundtable and workshop, and we involve with the community people, and we try to disseminate the dangerous sections and all those things of this draft bill. And then we come with some recommendations to the government. Please review the bill before enacting in the parliament. And we have organized also the press conference. The first time after that press conference, the Bangladeshi media, they come to know about the draft citizenship bill, and they have started writing about this bill, reviewing the bill before going to the parliament. And then we organize a radio show, and then we try to invite UNHCR people and some expert from the legal side. After that, we drafted the 2 recommendation paper and 1 flyer about the sections of this draft bill, and we have distributed this recommendation papers to Home Ministry, Law Ministry, and every concern of the Bangladesh. But still, this bill is silenced there. Anytime it will be in the parliament, and then it will be enacted. So we are really concerned if this bill will be enacted, then again we lost our citizenship. Even not only just Bihari, some more people in Bangladesh, they will be stateless. And international level, we have submitted last year UPR. We have focused on the draft citizenship bill, and we have attended the regional meeting and also Minority Forum. I have presented some paper on Minority Forum, and we are trying to focus on the bill. This is really concern for us and some other community people, those who are in Bangladesh. If this bill will be enacted, then it will be really a disaster for us. Thank you.
Thank you, Khalid. Ravi.
So, yeah. Thank you. Thank you, Joshua. So how much time is left? 10 minutes, okay. Thank you, Joshua, and thanks to the speakers before me. And thanks to everybody, all of you who has come here for this session. And thank you to Fernand, who has mentioned about Assam, and also that letting us know that you and your colleagues will be issuing a press release today on Assam. So my presentation is both, in a way, it gives some basic information on what is going on in Assam, and as well as some analysis of it, how it is related to migration and colonial past and minorities and other related issues. So presently, there is a citizenship process going on, which has been going on since the last 3 years. And now, as of now, it excludes more than 4 million people from citizenship. Now, this is, sorry. So just to give you an idea of where Assam is, actually, I mean, and it is very much in the background, which I'll come to that later, in the presentation that Khalid made. You see that, Bangladesh, Assam is basically sandwiched. It's part of a region in India which is sandwiched between Bangladesh and China. And this is an area where there has been a lot of migration has taken place, not just in the recent past, but there is a long tradition of migration of various tribes from China who originated from China and Burma as well. So the dominant community in Assam, who are called the Ahoms. So the Ahoms, basically, they themselves were also Burmese. So they came and attacked Assam, and they became the dominant community there. So it's a region which has seen a lot of migration in the whole region, and then, of course, also the Bengali migration. Yeah, please, next one. So some highlights of the Nrc process, and it's considered to be an updated version of what India they claim to have made in 1951. Immediately after independence of India, there was a National Register of Citizens, but it was actually based on the census that was conducted. So whatever data was there in the census, the same thing actually became the National Register. So now what is going on is considered to be a process of updating that 1951 NRC, and it requires the applicants, all residents of Assam state are required to apply for inclusion, and with documentation showing that the applicant or his or her ancestor lived in Assam before this particular date, and link the applicant himself or herself with this, what is called the legacy person. So the person who lived in before 1971 is called the legacy person, and the applicant has to prove that he has relationship with this applicant. So this date, you will notice that this is very, it goes to Bangladesh. So this date is 1 day prior to the date that Bangladesh was declared independence. So basically the logic is that during the 1971 war, when Bangladesh was liberated, there were 10 million Bangladeshi refugees, Bengali refugees in India, during that war. So the logic is that all those who were refugees in India at that point in time, they were required to go back. And then, so those who remained after that date, those who came before that date could claim to be citizens of India, but then those who came after that are considered to be living in India illegally because they were supposed to go back. And one of the serious gaps in the whole NRC process is that there is absolutely no clarity on what would be the status of those who will be left out. There's whether they will, what they will be, whether they'll be citizens, non-citizens, foreigners, stateless. So the Indian government and the Indian Supreme Court, which is overseeing the whole process, has not clarified on what would be the status of those people. Yeah, next one. So as things stand now, 4 million persons are excluded from a list that was published in last July. And then after publishing the last July list, there was time for those who were excluded to reapply with new documentation, etc. So that happened in last December. And then during early this year, February to till very recently, there were so-called hearings. So all those who had applied for reapplied for inclusion were called to these various centers, and they were supposed to give oral evidence to the documentation that they had given. So people had to take, in some cases, 20, 25 relatives, and in some places, the centers were not very close. Centers were 200 kilometers away from where they lived. So it basically caused a lot of hardships to the people who are excluded. Now, after this hearing has finished, yesterday the government came out with a new list, which actually increased the number of exclusions. On the contrary, so those whose cases were put on hold were excluded from the list. So those who were actually included, about 100,000 of them, have been now excluded. So from 4 million, about 4.1 million, 1.7 million it was earlier. So now it has become more than 4.2 million, 4.25 million or so. And the most affected are children, women, and that's because they don't have documentation. And there is a lot of practice of child marriage. So women are married when they are children, and so basically and the women have to apply with the documentation of their parental family. So they cannot claim citizenship from marriage. They have to claim citizenship from the parental family. So since child marriage is practiced, widely practiced, girls and women have no documentation when they are married. They don't have a voter because they were under 18 when they were married. So they don't have a voter ID, which is an essential document that everyone has to have. And various other, land documents. Generally, women don't own land, so there are no land documents. There are no house ownership documents and things like that. Again, with the children, there has been, now Assam government claims that the birth registrations are about 70%. So 70% of children who are being born even now have birth certificates. But then consider that 10, 15 years ago, so children who are about 14 years, 15 years now, they did not have birth certificates. And since there is a lot of illiteracy, a lot of children did not go to school, there are no school certificates. So there is a massive exclusion of children as well. And also another thing is that Assam is a place where there is one very big river, the Brahmaputra River. And the Brahmaputra River is what is called a braided river. It keeps changing its its flow in various places, and there is a lot of flooding, and there's a lot of river erosion. And because of that, villages keep shifting a lot. So according to an IOM report on climate change in Assam, in the last about 20 years, 180 villages have disappeared in Assam. And Assam is also a place where there are a large number of river islands. So one of the largest river islands in the world is in Assam, in the Brahmaputra River. So the targeted people are also people who are excluded are these people who have shifted their villages, in the last 20, 30 years, because shifting often causes documentation to be lost and to be targeted as Bangladeshi migrants, because they build new houses. When they shift, they build new houses. So since they are building new houses, the authorities think that these must be new Bangladeshi migrants. Yep, next one, please. So now the final list will be published by the end of July. Then we will know actually how many will be excluded. And even as this is being finalized, the government has come out with an order saying that all those who will be excluded from the NRC will have to go to these foreigners tribunals. I mean, very notorious foreigners tribunals who are very notorious for excluding people arbitrarily on the basis of discrepancies in names and things like that. But in the next one, I'll come to the what that foreigners tribunal is. So just going back to the whole thing when it started. So the whole issue of a lot of illegal Bangladeshi migrants being present in Assam became a highly contested political issue in the 1980s. There was a campaign, often violent campaign by the dominant Assamese to seeking eviction of suspected illegal Bangladeshi migrants. So then the government of India came to an agreement which is called the Assam Accord in 1984. And that basically, in that the government committed to have a regime of detecting and deleting. So basically the whole thing started from a voters list, and it was suspected that the updated voters list in 1984 had, 1980s or so, it had a lot of names of Bangladeshi migrants. So then initially it was basically deleting names of suspected Bangladeshis as from the voters list, but then it went on and it resulted in so the Assam Border Police was set up, which has powers under the Foreigners Act to target anyone accusing the person. 2 minutes? Okay, I'll try. Targeting anyone as foreigner. So between 1998, so the foreigners tribunals were set up. So between 1998 and 2016, 80,000 people have already. So what is less known about Assam is that statelessness is already there. It is not that NRC is going to create statelessness. So these individuals who have already been declared foreigners without a confirmation of what nationality they are, and many of them are languishing in detention center, 1,000 of them, they are already stateless. And definitely there is a process between India and Bangladesh to identify who are Bangladeshis. So Bangladesh, obviously there are about 100,000 people. Bangladesh has taken back some 25 people till now. That is what reports say. So which obviously means that Bangladesh is not in a position to confirm the nationality of these people. Yeah, let's go to the next one. Now, a little bit going back, this is the colonial legacy of what, you were also talking and Khalid was saying, So Bengal was the first one by the colonial government to be colonized. And then because of there was large-scale migration of peasants from Bengal to Assam, and that was promoted by the colonial government because it increased the revenue of the colonial government. And Bengal was also, since it was the first one, the British colonial government trained a lot of Bengali clerks and officials, and so they were, in fact, in Burma as well, a large number of officials, and in the police there were a lot of Bengalis. So that's how the Bengali migration started. And then again, in 1947, when India was divided between Pakistan and India, and later on in 1971, there was a lot of forced migration. Khalid's, is his father's forefathers. They moved to Bangladesh from eastern state of Bihar and Uttar Pradesh, and a lot of people in the western India moved to Pakistan, and many thousands of millions of Hindus and Sikhs from Pakistan moved. So that again, history is there. And then colonial India was divided on the basis of religious lines. That is one, what we have seen in Assam today is a offshoot of that. Yeah, please. Now coming back to this current scenario, July is when it is going to be finalized, and so the government, in order to deal with this, since they have said that everybody has to go to these foreigners' tribunals, the government has plans to 100 are already being set up. So 1,000 foreigner tribunals are to be set up so that all those excluded, 4 million, will have to apply to these tribunals, and they will have to get themselves, try and get themselves certified as Indian citizens through these foreigner tribunals. And again, there is no clarity. One thing I would like to say, Fernand, you were also saying, in terms of the impact, those who were declared foreigners, and also there has been this process of what is called the doubtful voter. So the Election Commission of India started in the 1990s an exercise where in the voter list they will mark anyone as D. So the D word would come. So that means the doubtful voter. So the doubtful voters and those declared foreigners, their right to access food subsidies. The government has this large network of food subsidies. So the Food and Civil Supplies Department would write to these small shops who give subsidized food, saying that these persons are doubtful voters and foreigners. They should not get subsidized food. So that we already have. And also the voting rights were taken away. So the least impact that the NRC exclusion will have, we already know. Some of them we already know, that their voting rights may be taken away and their food subsidies will be stopped. Whether their children will be able to go to schools or not, we don't know. Yeah, the next one. Now, at the same time, just 1 minute I'll take. At the same time when the NRC is going on, you see, from right now, from the NRC, the major exclusions are of people of Bengali ethnicity, both Hindus and Muslims. Now, through this amendment to the Citizenship Act, the government is trying to give citizenship to any non-Muslim from our neighboring countries, Bangladesh, Pakistan, and Afghanistan. So through this, they are going to include in citizenship the Hindus who are excluded in Assam, finally leaving only the Muslims who will be stateless. Next one. Now, in terms of international response, none of course, we are in touch with many embassies in Delhi, and they are still watching. They're not saying anything at the moment. But the rapporteurs, UN rapporteurs have written, including Fernand, to the government. But then the government has not responded to their letter. And probably because the government themselves don't know. And it is certainly a very, very major, as Fernand also pointed out, a very major thing which is going to destabilize the entire population. And it will have implications not just for the South Asian region and maybe possibly to Southeast Asian region, but as well as internationally. I mean, we really don't know what is going to happen. The exclusions, for example, say school exclusion, though there may not be a policy, but on ground, we know that there's a lot of discrimination against Muslims. So even though policy may not be there, but then on ground, it will strengthen the discriminatory practices against the minorities. And so, next one, yeah. So what we have done till now, one of the things is that, DAGI and Statelessness Network, Asia Pacific, we have started a small community resource center in one of the districts, and where we are trying to help people apply for inclusion and trying to work with the lawyers, because many of them will have to go to the foreigner tribunals. And we're also building a batch of volunteers. Now, before that, we have there's a research report. Some of you, but this is more of a it's focused on the experiences with the bureaucracy of NRC of the people. And after that, of course, we have done for ISI in the paperless people publication. If you see podcasts which ISI has produced, we have documented cases of 2 excluded families with that. So some of these research reports I have, if anyone is interested, you can take from me, but it's also available online. So this is what we are trying to do. Thank you.
Thank you, Ravi, and thank you for your indulgence. We have gone over time, but I think the issues are complicated, and it didn't seem appropriate to try and interrupt midstream in trying to understand these. We have a few minutes for comments, I think, more than questions, and I would encourage you in the quite long breaks to try and engage our participants. But Melanie, you have a question.
I just wanted to sort of mark, by way of a comment, how much change we've seen in the discourse about statelessness in a very short period of time. Not very long ago, UNHCR and most other actors in this space were talking about statelessness as something caused by gaps and conflicts in nationality laws. And I think it's very appropriate that we're all now talking about discrimination as a leading cause of statelessness. At the same time, I don't think we should be talking about discrimination as the exclusive cause of statelessness. And in that regard, because the special rapporteur mentioned the 75% of the world's stateless people being members of minority groups, and because that statistic comes from a report that UNHCR published in 2017 on stateless minorities, I feel obliged to point out that when we put that in there, we qualified it with 75% of the world's known stateless populations. So the truth is, we don't actually know what percentage of the world's stateless populations are members of minority groups because we have such limited data on the stateless population. So we were basing that on the populations that UNHCR counts in its Global Trends report. And just also on UNHCR's mandate, you're very right that when UNHCR was founded in 1951, when the statute was adopted by the General Assembly, we had a mandate to work on stateless refugees. And indeed, the issue of statelessness and the refugee issue were understood by everybody as intimately connected post-World War II. But since then, of course, the world has moved on, and UNHCR's statelessness mandate has been expanded several times by the General Assembly. We now have a mandate to work on statelessness, not just stateless refugees. And indeed, UNHCR does not consider statelessness to be just a quote-unquote humanitarian problem. I think that's evidenced by the fact that we have a mandate to work on the prevention of statelessness conferred on us by the General Assembly. We don't have a mandate to work on the prevention of humanitarian situations. We don't have a mandate to work on the prevention of refugee flows or IDP flows, but we have a mandate to work on the prevention of statelessness because we know how to do it. It's fully preventable, right? It's just about the adoption of international standards and best practices in nationality laws, civil registration laws, and so on. And just final little errata or correction, we do actually talk about stateless minorities on page 14 of the Global Action Plan and call for the elimination of all forms of discrimination from nationality laws in Action 4.
Thank you, Melanie.
Thanks.
There's two more comments, I think, and also, the issue on structural discrimination, I think, is important to bear. Okay, please.
Oh, thank you. I'm very fascinated by the question of discrimination against stateless people, and I think this came up in all of the presentations. I was particularly noting when Julia talked about it, the transformation of the discourse and the words that people have started using, where you had, to a certain extent, indigenous communities or communities of people living in close proximity to one another who were then divided by borders or moved from areas against their will, and then the transformation of the use of the term migrant or foreigner or illegal migrant that is kind of like cropped up in a lot of situations with minorities. And I find this very interesting because foreigners are a class of people where discrimination, a certain level of discrimination against foreigners is allowed in the global citizenship system. So if you can establish that someone is not from a certain place or country, then you do have a certain license to reduce their rights. And I think it's interesting how so many governments have seized on this language of, illegal or irregular foreigners or migrants who are coming from somewhere else and then using that as a justification. And my question is, I was wondering if you brought up the issue of labeling people as foreigners or trying to transform the name of a certain group to a different name that makes them seem less like they belong. And I was wondering if any of you had any thoughts on that particular question. Thank you.
Thank you very much. I think that's going to be, unfortunately, the last question. So any thoughts on the labeling of some of the communities you work with as foreigners in answer to that? Julia, you want to start?
Should we start? I have a feeling that there's a global trend, actually, when somebody who is labeled, many populist politicians use that, when somebody is labeled as illegal immigrant, that would mean that they do not have right to certain rights. And that is especially seen, so justification, this kind of justification is definitely used when it comes to stateless minorities as well. And it's interesting, we go back to the case of Roma. Roma have been in Europe for very, very, very long time. I mean, there are like cases, you can say in 10th century already, for example, when they do talk about Roma. But of course, borders have shifted since then. And it's easy because of the borders being shifted to say with Roma, okay, they're really not, they're a foreigner and so on. And they're constantly being made foreigners. But they're not the only basically stateless population that is made like this. And I'll finish, we can talk more about it later. But I think this is really an important observation, yeah.
I just wanted to add that in your description, you referred to discrimination that obviously some form of discrimination is allowed or is normal between citizens and those who are not. I would qualify that in this way. Differences of treatment between individuals, some of whom may not be citizens, are permitted. Discrimination is never allowed in terms of international human rights. I think this is a matter of the language used, the terms we use, and misunderstanding. You used the word discrimination in perhaps a more common way. But in terms of the human rights, it's never permissible to discriminate. So some differences of treatment, and that's the point we were making earlier, some differences of treatment involving non-citizens, and I agree, I don't have a better term, but I think foreigners should be avoided. They're citizens or they're not. Some differences of treatment in relation to non-citizens are quite permissible. They're quite reasonable and justified. But there are other situations where they're not, and that constitutes discrimination, which has to be prohibited or has to be rejected at all costs. Access to education is one of those. I don't think, and here I'm advancing a little bit, to my recollection, it is not permissible to deny education to children, even if they are not citizens. So this is where I think we have to make a distinction between what is discriminatory and what is differences of treatment which are reasonable and justified. So I think perhaps that's one response.
Just to respond on issues of branding people as foreigners, my community has been victims of that. In 1997, there were clashes in Kibera, my area that I come from. In 2000 also there was a clash because basically in order to inherit the Nubian community, we were branded as non-Kenyans. So that because we're in a prime land, it's 5 minutes drive from the capital city. So basically, the easiest way to disinherit a community is by making the majority see that the minority do not belong. So that there is no day that the majority will side with the minority. So that even if you want to discriminate them, there'll be no one to hold you accountable. It's a blanket cover that the government basically uses to soothe the majority that it's for your own interest that these people should not be here. And we've seen a backlash in my community, and that's the reason as to why in my presentation I noted that in 2001 we just decided to go to court and seek interpretation whether we were Kenyans or not.
It's the same, like for the Urdu-speaking people, it is still going on, the branding as a non-Bengalis and non-citizen, because we got our citizenship and the voting rights from the High Court, and it is quite difficult in Bangladesh, so everybody knows about the court judgment. Even the government department, they don't have any idea about the Biharis. It's still the ministers, when they visit Pakistan, and before going to the Pakistan, they just make a press conference and they say, okay, now we are going to Pakistan and we have a very top issues like the Biharis, repatriation of the Biharis, and some other issues like government to government. So if the minister is saying we are going to talk with the government of Pakistan about the repatriation of Biharis, so you can think about the in general people. That means he or she doesn't know about the 2008 judgment and 2003 judgment. So it is really unfortunate for the Bihari people. So we are really trying to disseminate the message of 2008 in everywhere, in every department of the government, and as well as in the civil society. The people have to know the Biharis are citizens within the 2008 court judgment, because they are living in the camp situations. The camp is treated as a refugee camps or stateless camps. So this is important to know about. In the mainstream community, the people are living in the camp, they are Bihari, they speak Urdu, but they are Bangladeshi citizen.
Thank you. Yes, foreigners can be some rights. I mean, basically the voting right. I mean, what is the basic thing? I mean, citizens are only entitled to vote and elect a government. So beyond that, maybe also states can deny passport to foreigners. But beyond that, other kind of discriminations are, in my view, are completely unjustified. And now, and putting people in detention, suspected foreigners in detention, that is completely a violation of human rights. Now, in the case of Assam, the complication is that, you see, it requires one to produce a documentation of 50 years old. And in a country where documentation, the government itself has not kept documentation properly. There is absolutely no uniformity in documentation. Different kinds of documentations exist, and there are a lot of discrepancies. So most of the exclusions of NRC, what we understand is that 25 to 30% of the exclusions are based on very minor discrepancies in names. For example, Akbar is spelt in a different way in 1970, and it is spelt in a different way in 2000, things like that, and then dates it. And there is very clearly arbitrarily targeting, when it comes to the foreigner tribunals. So we have had a recent case of an ex-soldier who served in the Indian Army for 30 years, and he's a decorated soldier. He was declared a foreigner by the foreigner tribunal and sent to detention. I mean, how can you, so arbitrary it is, the kind of, so in a family, the mother is a foreigner, the children are declared Indian citizens. So these kind of completely, it's a bizarre and completely, and what is the worst is that in Assam, people go by some imagined numbers. 4 million Bangladeshis are there. So this has been going on in India for many years now. The Bangladeshi politics has been going on. So there are randomly figures are quoted. It must be 4 million, it must be 10 million, it must be 15 million. So people will say anything like that. And that affects the bureaucracy at the lower level. So bureaucracy goes by quotas. So the foreigners are targeted, people are targeted as foreigners on the basis of some imagined numbers. Oh, these many must be there. So like that. So that is the problem in Assam.
Well, colleagues, thank you very much. I mean, you can see if you thought that identity politics, somehow there's been a recalcitrance to try and talk about identity politics, that somehow human rights were going to be the answer to everything. But you can see in states old and new that actually who you are makes a big difference to the extent to which you can access your rights. And I thank our panelists for being able to demonstrate them in such vivid detail in each of the contexts we've seen. Thank you very much.